हेलो स्टूडेंट, वेलकम टू श्रीराम IAS। आप सबका स्वागत है इस क्लास के अंदर। वो जो करंट अफेयर की क्लासेस हैं फॉर पॉलिटी फॉर योर अपकमिंग एग्जामिनेशन ऑफ प्रीलिम्स 2025 ऑन 25th of May। You must remember the date and start preparing for current affairs for polity. Thank you very much for joining me. We'll be taking up a new topic. You all know that Citizenship Amendment Act was passed in 2019, and for every act there are rules to be implemented. Now those rules have been made in 2024 and we are going to discuss what those rules say, but a little bit of introduction of Citizenship Amendment Act is needed for your upcoming prelims examination. Let's dive deep. Citizenship Amendment Act के rules हैं ये. Act was passed in Citizenship Amendment Act was passed in 2019. There are several amendments to the primary act which was made in 1955. Citizenship Act of 1955. There are many amendments which were made to this particular Citizenship Act of 1955. It was amended in 1986. It was again amended in 2003. Then major amendments, I am telling it happened again in 2019 for different reasons. We are going to see what reasons were there, what changes were brought when it was amended in these years. So in these rules, two important things have been written, that the applicants, whoever are from the 6 community from 3 different countries. What these countries are: people, persecuted minorities in Pakistan, in Afghanistan and in Bangladesh. Persecuted minorities can seek citizenship of India. Now from these 3 countries there are 6 communities which are being specified. So which 6 communities are there? Hindus, Sikh, Christian, Parsis, Jains and Buddhists. They are considered as persecuted minorities. Whoever think that they should move to India and seek a citizenship here in India, if they belong to these 3 countries, if they belong to any one of these particular religion or community, they can come here and seek citizenship, request for citizenship, and they are going to get the citizenship. There are several requirements, more requirements. First is that you have to be from these 3 countries. Second is you have to be from one of these religions. Let me remind you, Islam, Muslims are not included in these persecuted minorities, and that is the reason why the Amendment Act of 2019 is criticized, because it is discriminating on the basis of religion. This is the major criticism which is given to this particular amendment. So third one is that anybody who wants the citizenship and has entered India before the cutoff date of 2014, in 2014, anybody on 31st of December 2014 before this date has entered India, and if the person is living here for 5 years continuously, because the time for naturalization was 11 years, which has been now reduced to 5 years in this particular matter. Anybody who enters India before this date or on this date, 31st of December 2014, and if they are living in India from last 5 years continuously, they are eligible to get citizenship. Several areas, they must not migrate to several areas in India which have been exempted from Citizenship Amendment Act. So the rules state, now this was the act and we are talking about rules because rules have been made in 2024. Now what does rule says? Rule state that applicants will have to provide 6 type of documents. Now who are these applicants? These applicants are from these countries and from persecuted minorities in these countries. Okay, and specify the date of entry. Date of entry in India. Why? Because it is one of the major requirement here that anybody who is entering India on 31st December 2014 or before that will be considered for citizenship, not people who are entering India after this date. Let us go to the second slide and see. March 2024, the government of India officially notified the Citizenship Amendment Rules of 2024. That is the reason why it was in current affairs. It is important for your prelims examination. And the objective was to implement provisions of Citizenship Amendment Act of 2019. Now, if you see citizenship in India, it is given in part 2 of the Constitution. Part 2 of the Constitution, starting from article number 5 to article number 11, talks about citizenship in India, but before the commencement of the Constitution. At the commencement of the Constitution means on 26th of January 1950, who all are going to be citizen of India is decided by these articles from 5 to 11. Now, who are going to become citizens of India after the commencement of Constitution? Means after 26th of January 1950 has to be decided by Parliament, and that is the reason in 1955 Parliament brought this particular Citizenship Act of 1955. It specifies several grounds on which you can seek for citizenship in India. Also, you can renounce or terminate or be deprived from the citizenship. All the provisions are given in this act made by the Parliament. And let me remind you, citizenship is the part of the union list under article 246 schedule number 7, and that is the reason why Parliament makes all the law. In India we have a single citizenship. All the states doesn't have their own citizenship. There is no concept of dual citizenship in India. So every person at the commencement of the Constitution, if the person is domiciled in India, born in India, or either of their parents were born in India, or people who have been living in India for more than 5 years, will get the citizenship of India. Now, this was during the commencement. On this date, 26th of January 1950, whoever is the citizen of India, according to Article 5 to 11, will remain citizen of India, but from there on, it will be the decision of Parliament. That is the reason this act was passed. Okay. Now we are going to see about what the Citizenship Act of 1955 said. It governs the acquisition, renunciation and termination of citizenship. Provides for citizenship by birth, descent, registration, naturalization and incorporation of territory into the Indian Union. Now, key amendments. Now, one act came in 1955, but key amendments were made into this act. First amendment came in 1986, where the citizenship has been tightened a little, and the clause that either of the parents, either father or the mother of the person who is born in India has to be the citizen of India. That simply means if you were born in India and either of your parents, either father or mother, are not the citizen of India, you will not get the citizenship. Before that, this clause was not present. So that is the change which was brought by 1986 amendment. It was amended again in 2003. Why it was amended? To introduce the concept of overseas citizenship of India and tighten rules for citizenship by birth. Pardon me, I am not well, so but anyway we have to do this current affair classes, so bear with me. Sorry for the coughing and everything. Amendment was again made in 2003. Then a next amendment came in 2019. It was a very controversial amendment. It gave fast track citizenship to 6 persecuted minorities from 3 countries who are neighbors of India, excluding Muslims, which created a controversy that the decision of the government, the act, is discriminatory, and it is discriminatory against the persecuted Muslims. Now let's come to the next slide. Citizenship Amendment Act of 2019. So it was passed on, enacted on 11th of December 2019. Provides citizenship to persecuted minorities. We have already seen Pakistan, Bangladesh, Afghanistan, to communities. These are the communities, 6 communities. The eligibility criteria is migrant must have entered before 31st December 2014. We have seen. And the residency requirement has been reduced from 11 years to 5 years. Important criterias are there to get fast track citizenship in India, that you must be from 3 different specified countries, you must be a persecuted minorities, which is also specified, you must be entering India before 31st of December 2014, and you must be here for about 5 years before applying for citizenship. Okay, coming to the next slide. Exemptions are also given, areas where CAA will not be applied. So autonomous councils under 6th schedule, CAA will not apply to this. This is very important for a prelims examination. They may ask a question where they can give which of the following areas were excluded from the Citizenship Amendment Bill of 2019. So try to remember this: autonomous council under 6th schedule, Karbi Anglong and the other Bodoland territorial areas, Garo Hills in Meghalaya, tribal areas in Tripura, inner line permit areas. Now there are 4 states in northeast which has this inner line permit areas: Arunachal, Nagaland, Mizoram and Manipur. In these areas, Citizenship Amendment Act of 2019 will not be applied. Reasons for exception: what are the reasons for exception? To protect the tribals. See, if outside people, the city dwellers will go and get settled in the tribal areas, so there may be a change of demography. It will be, you know, a danger to their culture. They have been very sensitive about their culture. Revolts have happened for this reason against the Britishers. We all have studied in history. So this is not allowed. This must not be allowed. And that is the reason, in order to keep the tribal areas and their culture intact, no person shall be allowed to live, to settle there. See, the city dwellers have already made their cities concrete, barren, concretization is everywhere. Now there is chaos, there is all kind of tension and everything. And now those people, just to find peace, wants to go and live in tribal areas. That simply will not be allowed because of the welfare of the tribal communities in India. That is the reason. Coming to next slide, Citizenship Amendment Rules. Now, because of the Act, the rules are passed in 2024. So it modifies, this is an important word, the rules made in 2009. Okay, to implement the Citizenship Amendment Act of 2019. Eligible applicants, we have already seen who are the eligible applicants. They are adding to the list that any person for naturalization and registration also. We have already seen 6 persecuted minorities from 3 countries. Okay, and additionally, if somebody wants citizenship through naturalization or registration, they are also eligible. And who are the people who will be eligible? Persons of Indian origin. They want to take Indian citizenship, allowed. Spouses of Indian citizen, minor children of Indian citizen, individuals whose parents are registered Indian citizens, and overseas citizen of India card holders. They all will be allowed. They will be eligible applicants under Citizenship Amendment Rules of 2024. Application process is very simple. Electronic submission, okay, under this particular section 6B of the Citizenship Act has to be made. So the process has been made online, electronic. You can sit at your home and submit the application. The application then goes to the empowered committee via district level committee. It's a natural, normal process followed in governance. Okay, and then the applicant must take an oath of allegiance. There are very interesting things which the person must know. See, they must have documents, at least 20. A list of 20 documents has been given, such as license, a driving license or Aadhaar card or visas, permits, census, anything. If you have to show that, you have to submit that. That is the proof which you have to give if you want Indian citizenship. And additional requirements are also there. And we are talking about these section of people here. These section of people here. We are not talking about people who have entered India before 31st of December 2014 from 3 countries who are the members of 6 persecuted minorities, because how will they have visas and how will they have driving licenses? We are talking about these people, person of Indian origin, spouse, parents, OCI card holders, and everybody. They must have at least one of the 20 document they can submit and seek the citizenship of India. Additional requirement is declaration renouncing previous nationality. It's simply under this Citizenship Amendment Act of 1955, you can either renunciate your citizenship, okay, means you can give away your citizenship. You can just make a declaration to the government that I don't want to be anymore the citizen of India. This is called renunciation. Then second is that when you take the citizenship of other country, your Indian citizenship is automatically terminated, because in India the concept of one single citizenship is followed. And then the third way of taking away your citizenship is deprivation, where the government deprives you of the Indian citizenship. These are 3 important grounds on which citizenship can be left in India according to the 1955 Citizenship Act. And here the requirement is that if you are taking Indian citizenship, automatically you have to just give away your previous citizenship from whichever country you were in, wherever you were living. If you want to become Indian citizen, you just have to renounce their citizenship. Then affidavit by the Indian citizen confirming the applicant's character. You must not be a person who has done crimes. You must not be a wanted person somewhere. The character certificate is very much needed, that India is giving you this facility of giving the citizenship. So something must be there. You must be at least a good person. We don't want to give citizenship to criminals. So you have to submit this affidavit of character. This is another requirement. And proficiency in any language mentioned in 8th schedule. If you have proficiency, you can speak Hindi, can speak other Indian languages. If you know one of them, you can get the Indian citizenship. So this is about the rules of citizenship, rules which are recently been passed in 2024 to implement the Citizenship Amendment Act of 2019. These rules were earlier made in 2009. The rules which are made now in 2024 is going to replace those 2009 rules, and it will help in smooth functioning of the governance because of the several requirements made, because of the several things which have been made clear through this particular legislation. Thank you very much for joining me. We'll come in the next class with the next important topic. Till then, bye bye. Jai Hind.